Are you struggling to pass your real estate exam? Well, you want to stay on here and review practice questions for national and for Texas State toward the end of the session. Sorry, I thought I had already started and I just noticed I had not clicked the go live button twice. So I'm continuing with the blue book that is sold by the Stephen Metley family on YouTube. And so let me show it to you again because I had already showed it, but I wasn't live. So thank you for those of you that are on here. And my apologies for thinking I already started. This is the blue book that we're using. This says, but there's one, they have books like this for, I don't know, maybe up to 30 states now. All of them have national questions and they have state particular questions. Oh my goodness. Here I go again. I'm off today a little bit. All right, this is the book. All right. So I just mentioned already about it. And we're starting with question number 216, reviewing encumbrances, liens, title transfers, and recording leases, types of questions. And this is the test number 2 in this book for national questions. Number 17, a property owner, oh, pardon me. Number 16, a homeowner defaults on his mortgage loan in the subsequent directly instead of initiating a court-ordered public sale. A lot of foreclosures are done at the courthouse steps every month. Others are not in this case. This is an example of A, strict foreclosure, B, judicial foreclosure, C, non-judicial foreclosure, or a deed in lieu of foreclosure. All of these are vocabulary. The answer here, which is already posted, is A. It is a strict foreclosure. And a strict foreclosure is a court proceeding that gives the lender title directly by court order instead of giving cash proceeds from a public sale. On default, the lender gives the borrower off official notice. So the borrower does get official notice. After a prescribed period, the lender files suit in court upon where the court establishes a period within which the defaulting party must repay the amounts owed. If the default does not repay the funds, the court order transfers a full legal title to the lender. That is a strict foreclosure. In Texas, we have non-judicial foreclosure. There's about 50 states that have non-judicial and about 50 states that have judicial foreclosure. Judicial, as the word says, has to go through the court, through the judge to get a court order in order to sell it. Non-judicial, the deed of trust already describes how the foreclosure takes process, and the trustee does that. Because whenever there's a trust, there are 3 parties, okay? The trustor, the trustee, and the beneficiary. The trustor can be the individual that the beneficiary entrusts in order to give orders to the trustee on what to do with that property. You know, getting a loan, getting a foreclosure, sending out legal letters, that notices, that type of thing. The beneficiary is the actual owner. Sometimes the beneficiary is also the trustor. However, in multiple asset protection, the beneficiary will not be the trustor. It'll be another name used for the trust. Number 17, a property owner gives Deanna permission to cross his property as a shortcut to her kindergarten school bus. One day, the property owner dies. With what right does Deanna grant? What right was Deanna granted originally, and will it survive the owner's death? A, personal easement in gross, which continues after the owner's death. So easement in gross, vocabulary. B, an easement by prescription, another vocabulary, which continues after the owner's death. Or C, a license which continues after the owner's death. Or D, a license which terminates upon the owner's death. So which is the answer that Deanna was given permission and granted to be able to use a shortcut going through that property for the kindergarten school bus? The answer here to number 17 is D, a license which terminates upon the owner's death. It's not an easement. So it was just a license which permits her to use that shortcut to her kindergarten school bus. If it was an easement, it would be recorded at the courthouse and it goes with the property. Any easement that's recorded on that property, the owner is the servant party and the person using the easement is the dominant party. Look those up in your information so that you understand these. Number 18. On two adjacent properties, adjacent vocabulary, there is an easement vocabulary that allows property A to use the driveway that belongs to property B. Here, property A is said to be which of the following in relation to property B? Okay, let's read the question again. On the two adjacent properties, there is an easement that allows property A to use the driveway that belongs to property B. So property B is the owner of the easement, and property A is the one that has the right of use on that easement. So here, property A is said to be which of the following in relation to property B? A, subservient estate. B, servant tenement. C, senior tenement. Or D, dominant tenant. So who is A in this situation? Because A is the one using the property or the easement that belongs to A, right? So the answer here, that belongs to B. So the answer here is the dominant tenement. So an easement appurtenant, that means an easement that's attached to the property, gives a property owner the right of usage to portions of an adjoining property owned by another party. The property enjoying the usage right is called the dominant party. So they don't own the easement. They have the right to use it. They are the dominant party or the dominant estate. The property containing, or here it says dominant tenement. So the property containing the physical easement itself is the servient tenement. So look up servient tenement, look up all these different answers on here so that you understand what each one means in the vocabulary. And I will stress over and over that in order to pass this exam, it's very important for you to know the vocabulary. Vocabulary, and more vocabulary. Okay. I studied it every day when I was learning this, when I was preparing for my exam. Okay. Number 19. A property owner who is selling her land wants to control how it is used in the future. She might accomplish her aim by means of what? A, an injunction. B, a deed restriction. C, an easement. Or D, a land trust. All of these answers are vocabulary. We're on number 19. So the owner wants to control how the property is used in the future. How may she accomplish this? The answer here is B. B as in boy, a deed restriction. So a deed restriction has further restrictions than what the city zoning has. So city zoning has certain restrictions. In order to create additional restrictions, first that owner has to meet the city zoning restrictions, and then they can add more. So whenever someone is purchasing this property and they go to the planning department, and the planning department, tells them, well, these are our restrictions. And if they don't look more into it and talk with the owner, and don't realize that there's a deed restriction, once they purchase that property, they're limited as to what they can do. And if not, the owner can fine them or tell them to remove whatever they added. So a private party who wants to control the quality of standards of a property can establish a deed restriction. A lot of times this is done on subdivisions where they want a particular type of home size, material used on the outside, 2-car garage or 1-car garage, driveway or no garage, sidewalks. All these are additional deed restrictions. So the deed restrictions take precedence over, as I mentioned, zoning ordinances if they are more restrictive. And typically deed restrictions are more restrictive than the zoning. Now, for those of you that are here, it's great to see you. This is for you, right? It's for you to prepare for your national and state exams. Well, this one for the national. So number 20, what distinguishes a lien from other types of encumbrances? So the question already tells you that a lien is an encumbrance, right? Something that is attached to the property and that can prevent that owner from selling it. So A, what distinguishes a lien from other types of property? A, it involves a monetary claim against the value of a property. B, it lowers the value of the property. Or C, it is created voluntarily by the property owner. Or D, it attaches to the property rather than to the owner of the property. So this is question 220, and we're doing national questions. So what distinguishes a lien from other types of encumbrances? The answer here is A. It involves a monetary claim against the value of the property. That is what a lien is. It can be a mortgage. It can be spousal support, child support. It can be a mechanical lien. Different types of liens. Those are monetary liens, and they are involuntary, right? Because the owner ends up doing something or hiring something or getting a loan or refinancing their property, and they end up with a mortgage or a lien that was attached to their property, so that whenever that property is sold, whoever put a lien on the property initially, property taxes. Okay, there's an order of seniority on different types of liens. Property taxes is first, and then the primary lien, the primary mortgage, that's number 2, and then other junior liens. To go back and review that when it comes to liens, what is the priority of the liens and what types of liens are there? Because there are different types of liens. Oops, 21. Okay, that's not going to work. Number 21. Which of the following defines an actual notice? Okay, what is an actual notice? That's vocabulary. A, it is notice published in a newspaper. B, it is knowledge one could have or should have obtained. C, it is a notice of explicitly stated in a legal document. Or D, it is knowledge received or imparted through direct experience. So what is an actual notice? The answer here is D. An actual notice, it is knowledge received or imparted through direct experience. So somebody actually came to you and gave you a piece of paper that gave you notice, no knowledge received. It can be writing, it can be verbal. Like when somebody gets a notice of divorce, okay, it's delivered in person, and the person that is supposed to deliver it, they'll keep trying and trying and looking for that individual until it's delivered to their hand. So that is an actual notice. There's different types of notices. Review that. And you can participate by typing your the question number and the letter answer. And if for some reason you get it incorrect, I'll explain it in a little bit more detail. Okay, number 22. So let me see if the answer gives other types of notices here. We were on number 21. So the term notice is synonymous with knowledge. The person has knowledge. A person who has received actual notice has actual knowledge of something. Receiving actual notice means learning or of something through direct experience or communication. Thus, a document in itself cannot be an actual notice. It is seeing of the document that makes it an actual notice. Kind of similar to also an eviction. I was an investor and I had tenants. It's best to post it on the door and give it to them in person. That's an actual notice. Because if you post it on the door, you may, oh, well, I never received it. I never got that notice. It wasn't on my door and I didn't get it in the mail. So you'd be amazed at the reasons that tenants can come up with, and landlords too. Okay, so it works both ways. So here's a different type of notice: constructive notice. Which of the following defines constructive notice? A, it is notice published in the newspaper. B, it is knowledge one could have or should have obtained. C, it is notice explicitly stated in a legal document. Or D, it is knowledge received or imparted through direct experience. Okay, we just did actual notice, right? Excuse me. So this one is constructive notice. Is it A, it is notice published in a paper? B, it is notice one could have or should have obtained. C, it is notice explicitly stated in a legal document. Or D, it is knowledge received or imparted through direct experience. So which one do you think it actually is? The answer here is B as in boy. It is knowledge one could have or should have obtained. For example, it may have been published in a newspaper, or you knew of that knowledge some other way. So it is knowledge one could have or should have obtained. You knew you were going through a divorce. You should have known that. Okay, you knew you got a ticket, right? And you had to present yourself to pay the ticket. So that is knowledge one could have or should have obtained. So constructive notice or legal notice is knowledge of a fact that a person could have or should have obtained. The foremost method of imparting constructive notice is by recordation or ownership documents in the public recording. So if there's a divorce decree or a divorce being applied for, then it'll be recorded in the courthouse and it'll be published in the newspapers and hopefully delivered to the individual, which typically happens. So recording at the courthouse is another way, right? Because it becomes a public record. Everybody has access to public records, specifically title records, since public records are open to everyone. So whenever a property is bought or sold, it is recorded at the courthouse. However, the individual who bought it, it's the best for them to also check up on it and confirm that it was recorded. And then after that, apply for homestead if it's their primary property. So the law generally presumes that when evidence of ownership is recorded, the public at large has received constructive notice of ownership. Okay, so the difference between constructive and actual, I'm going to you and giving you the piece of paper. I'm like, here, I'm letting you know this is a lien, or you're getting fined, or whatever it might be. Constructive, it's we should know because we knew somehow of it, or it was in the newspaper, or it was recorded, or it was verbally told to you, and you should have been aware. The same goes for our real estate license. There's going to be a lot of things that we should already know. We can't say, well, I wasn't aware of it. Well, we got educated about it. We took all these different courses. We get yearly training or every 2 years, and we should know certain things. We have knowledge of. We cannot use the excuse, well, I didn't read it, or no, I didn't know, or nobody gave it to me. That's not an excuse. We need to stay on top of it and know about the changes. Our brokers will let us know, but if you're not present, hey, then you have to make sure you're aware of it. All right, number 23. Did I type the answer? Yes. Ownership of real estate can be transferred voluntarily or involuntarily. The 3 ways title can be transferred: involuntarily, or by A, grant, deed, or will; B, escheat, deed, or covenant; C, title, certificate, will, and deed; or D, sale contract, deed, and warrant of seisin. So it says here, ownership of an estate that can be transferred voluntarily or involuntarily. There are 3 ways title can be transferred voluntarily. That means you are volunteering to transfer that title. You're aware of what's happening. You have knowledge and you're doing it personally. So is it A, grant, deed, and will; B, escheat, deed, and covenant? All these are vocabulary. C, title, certificate, will, and deed; or D, sale contract, deed, or warrant of seisin. And if you don't know some of these vocabularies, then go back and review. I'll be doing a vocabulary session. Maybe I'll do that next week. So the answer here, when we do something like that, voluntarily, of transferring property, it is A. We can use a grant, a deed, and a will. Granting somebody that property, or we have a warranty deed, a special warranty deed, a quitclaim deed, or we have it in a will. Okay, number 24. What is the function of recording a deed? What is the function of recording a deed? Okay, a warranty deed, a quitclaim deed, a special deed, a general deed. Different types of deeds. A, it makes the deed valid. B, it causes title to pass. C, it gives constructive notice of ownership. D, it removes all prior recorded encumbrances. All kinds of vocabulary here. Words we just used, constructive notice, right? So which one is the answer for the function of a recording of a deed? So when something gets recorded, what did I just mention in the prior question? It gives constructive notice of ownership. So it goes into the public records and it's visible to anybody who looks it up. That is constructive notice. That is the function of recording a deed. because you'd be amazed that there are individuals who don't own a property and they can sell it. They're fraudulent individuals and they can sell a property multiple times. And if the person that's buying doesn't double check that there is a deed or not recorded, then they're going to be defrauded. And it's reality. It does happen. So the answer here was D. We can't say, oh, well, I didn't check. Oh, well, I didn't know. Well, in order to protect our funds and buy something that is legal and it was with the actual owner, is do our research, do our due diligence. Number two, the only clause that is actually required in a deed is the A, habendum clause, B, granting clause, C, reserving clause, or D, tenendum clause. Lots of different clauses, right? The only clause that's required in the deed is the, so that's when title and ownership is transferring from one person to another. The owner of that property is the one that signs the deed. 225. The answer here is granting clause. So the owner is granting ownership to the new owner, the borrower, the granting clause. So let's see, the granting or premises clause is the only required clause. It contains the conveyance. What is conveyance? When property is transferred from one owner to another. Conveyance intentions. Names the parties, describes the property with the legal description, and indicates a nominal consideration. So if it has a loan, it'll say a vendor's lien. Okay, because the lender is attached to that property in order for them to get paid. Number 26, the type of deed that offers the grantee. So who's the grantee? Who's the grantor? The fullest protection against claims to the title is the A, general warranty deed, B, special warranty deed, C, quitclaim deed, or D, bargain and defend deed. So think about things. General is real broad. Special is specific. Quitclaim is something really quick. Bargain and defend deed, is that an actual deed? So again, vocabulary. So the broadest deed here is a general warranty deed. Think about the military. You know, one of the top offers, the main officer is the general. They cover everyone, everybody else below them, right? It's broad. That is the type of deed that offers the grantee, it's the new owner, the fullest protection against claims to the title of the property when it is being transferred, conveyed, sold. 226A. Any questions so far? If not, I'm moving right along. '27. Come on, get all in one page. Okay, I'm gonna have to make it smaller. There, quiet title. What is quiet title? A, to force the grantor. Who is the grantor? Remember, grantor, grantee, the OR, and the EE. To force the grantor to defend the title against a third-party claim. Who is the third party? B, to terminate a co-ownership estate when one co-owner is unwilling. C, to keep the owner's name out of the title records. Or D, to have an encumbrance removed if the lien holder cannot prove its validity. So what is the purpose of a quiet title? So you have a noisy title. What do you think noisy would be? Sometimes people don't like a lot of noise, right? A lot of drama. So that versus quiet. So what do you think it is? A, B, C, or D? The answer here is D. To have an encumbrance removed if the lien holder cannot prove its validity. Okay, so the lien holder could be the lender. The lien holder could be a hard money lender, somebody that loans out private money. An encumbrance, which is something that's attached to the property, right? And that can be a lien. So if there's a lien on the property, there's issues with names, there's issues with other types of liens, judgments, then to quiet the title in order to convey it from the owner, a grantor, to the buyer, the grantee becomes the new owner, is to have an encumbrance removed, something that's attached to that title, removed if the lien holder cannot prove its validity. So the lien holder can be the lender, the bank, a mechanic's lien, an individual that put a lien on the property, a mechanic's lien. It can be anything that has to deal with money collection. So 227D. Number 28. Sorry, I got new contacts today, so I'm also dealing with that. So please bear with me. Which of the following best describes the documentary stamp tax? What is a documentary stamp tax? A transfer tax based on the price of the property being conveyed. B, a tax a title company must pay in order to examine title records in the recorder's office. C, a tax collected by attorneys and paid to the state when transfer documents are prepared. Or D, a tax on stamps used to certify the authenticity of a conveyance. So transfer tax, tax a title company, the examined title records, conveyed, what's a stamp tax, transfer documents, what's authenticity, what's conveyance. All of those are vocabulary. So I keep looking to the right because my letters are bigger on the right than on my computer in front. And so I'm learning to adjust to these new contacts. So number 28, what is a documentary stamp tax? Is A transfer tax based on the price of the property being conveyed. So when international individuals buy a property here in the US and then sell it, and they're a foreign individual, then there is a foreign tax or there is a transfer tax. Some states have a transfer tax on properties. So that's what the best describes the documentary stamp tax. It is a transfer tax based on the price of the property being conveyed. We don't have that here in Texas. So a transfer tax, let's see what else. State law usually requires payment of a documentary state stamp tax on conveyance of real property. The tax is based on the actual price of the property conveyed, thus enabling taxing authorities to ascertain current market value for ad valorem tax purposes. Payment of the tax is evident on the deed. So some states have that. Here in Texas, we don't have that. But we do have ad valorem tax. So property taxes, yes, those do exist. And actually, Texas has one of the highest property taxes in the US of any state. However, we have a lot of other things that are lower. We don't have state tax, which a lot of other states do. And we have sales tax, which when I lived in Oregon, we didn't have sales tax, but we had the state tax. Number 29. The court proceeding that generally settles a decedent's estate is called. So the court proceeding that generally settles a decedent's estate is called A, testate, B, probate, C, escheat, or D, distribution. So how is decedent estate settled in a court proceeding? So in other words, when someone dies and they don't have a will, it goes to the court proceedings, right? And sometimes even when there is a will, but maybe it's not complete. And that's why a lot of times attorneys will recommend a deed, a trust, everything, so you don't have to go to probate. Oops. I just gave you the answer. The answer is probate. So court proceeding that generally settles a decedent's estate is called a probate. So a court proceeding called probate generally settles a decedent's estate, whether the person has died testate, having had a valid will. So testate is having a will. Intestate is without a will. So how one of my students let me know is that intestate and testate, you think of within or without. So intestate has the word in. So it's without and within. So without a will, it is intestate. They failed to do a will. So testate is with a will. Okay, 229B. Yep, got that. All right, number 30. If an owner, let me see if I can make it a little bit larger so that I can read it also better. See if I go to the next page. Nope, that's not going to work. All right, number 30. If an owner of real property dies intestate and has no legal heirs, what will happen to the property? So intestate, so testate, intestate. So within, without. So intestate is without a will, right? So A, it will escheat to the state or county. So here it is. The owner of a real property dies intestate and has no heirs. So they don't have a will and they don't have any heirs. What will happen to the property? A, it will escheat, vocabulary, to the state or the county. B, it will transfer to the decedent's executor. C, it will be divided equally among adjoining property owners. Or D, it will become a public easement. Okay, some of these right away you should know. Okay, it's not an easement. It doesn't go to adjoining owners, right? Owners that butt your property. And decedent's executor, that means they had heirs. Somebody that was an executor, would be an heir, or somebody that was assigned. Usually when it's assigned by the court, it's an administrator. If it's in a will, it's an executor. So intestate means they die without a will. So what is the answer here? It is escheat. It will go to the state or county. It will escheat to the state or county. And sometimes individuals that were friends of the property owner will say, hey, the owner told me that I was going to get it when they would die, and they feel cheated. So we say, escheat, they were cheated out of what the property owner stated. However, it was a verbal statement. It was not put in writing, and it can actually be written on a piece of paper, signed and dated, put in a box where somebody finds it, and it would become a valid document. It wasn't recorded, but it is considered a valid document, right? Because it was put in writing and it is the owner's signature. Somebody could fraudulent transpose the signature or copy the signature. And now it has to go through the courts to prove to see if that was the individual, the owner's real signature. Okay, so that's it for national questions today. Any questions on national? So in a moment, we're going to go into Texas state questions. So anybody here that is from the other 49 states, then you are welcome to stay. Of course, that would be great. However, you do not have to stay since we are now going to be reviewing Texas state questions only. And the book that we use, just for refresher, is this, the Texas Real Estate License Exam Prep by Metling. He's the main author. And this is the 4th edition book that they have published for Texas. So it is the current book after the state laws changed with the National Association of Realtors lawsuits and other things that took place, and new contracts for Texas Real Estate Commission or promulgated contracts were done for Texas. Okay, and this section that we were reviewing today, we were on encumbrances, test number 2, and I put that in the description so that you know it's national test number 2. We did questions 16 through 30. The prior sessions, prior Wednesdays, we did the same chapter on encumbrances, liens, title transfers, and leases. So I'm doing it consecutively on this book. Next week, I may do vocabulary because we do need some of that, since a lot of these questions on national had a lot of vocabulary in it. So for the state section, today we are on test number 13, which deals with standards of conduct in Texas brokerage and practice. All right, so. And we're starting with 1321. All right, there. So get ready. Some individuals that take the exam find that the national, which has a lot more questions, it's 80 or 85 questions, is a lot harder because there are so many questions. And however, others find that the Texas state exam is really tough because laws change in all the different states. And so we have to stay up with those. The national is pretty much the same throughout for all 50 states. All right, number 1320. We're doing Texas real estate. Oops. Oh, sorry. I'm trying to type it in the chat. Texas real estate practice exam. And please feel free to participate. Okay, here. All right, we're starting with 21. So isn't it nice? The weather is cooling up a little bit here in Texas. Well, we should say in the 90s, right? Right, number 21. A sales agent maintains a website where listing information is protected by a password. In this instance, such listing information is considered what? So, a sales agent maintains a website where listing information is protected by a password because we take control of the website, right? However, in this instance, such listing information is considered what? A, advertising subject to regulation. B, a website advertising subject to identification and requirements. C, not to be advertising due to the password protection. Or D, website scraping. Which do you think is the answer for 1321? So the answer here, since it is a protected website with a password, it is not to be advertising due to password protection. So let's see what the answer says. And that is a communication used to induce a consumer to use the licensee services. Since the user voluntarily signed up to the protection information, like they signed up to the website, the data itself cannot be considered an inducement. They voluntarily signed up and they put their name, their email, maybe also their phone number. So whatever made the consumer sign up was in fact the inducement, but it was voluntarily done by the individual, by the consumer, right? Maybe one of these days I'll hire somebody to type these up. But right now, that's not what I am doing. And I used it directly from the publisher's book, which I have permission to use. Okay, so I'm not violating the copyrights. That's why there's a disclosure in each video's description. There's a disclosure that was provided to me by the author, the Metling family, so that everybody knows, okay? And it's disclosed that we're using their books, their text. Number 22, which of the following would not, okay, be considered advertising? A text message to a friend to list her property. B, a billboard message to the general public. C, a phone message to a client. Or D, an email to prospective clients. Which one is not considered advertising? Y'all can participate and type your answer in the chat, okay? I would greatly appreciate that, and it would help you if for some reason you get it incorrect. So a phone message to a client, okay, that is not advertisement. We already have, it says a client, right? So we already have a relationship. A billboard, yes. A text message to a friend to list their property, yes, because we don't have it listed yet. They're not a client yet. An email to prospective clients. They're not clients yet. Prospective, a friend, a general public billboard message. Okay. The other was a phone message to whom? A client. There's already a legal relationship. The others do not have a relationship. Number 23. 23. One critical requirement of licensee advertising is that it, A, identify the name of the broker. B, identify a specific property. C, refrain from listing the broker's assumed name if it is not registered. Or D, avoid subjective and exaggerated descriptions. So which one do you think it is? So a critical requirement, right? It is A, we must always name the broker. If we are the broker, then it's our name or our brokerage name. However, if we're hanging our license under a particular broker, like Keller Williams, EXP, Coldwell Banker, Real, LPT, Remax, those are all brokers where we hang our license. In other words, our license is under them and we pay them a percentage of our commission in order to use their tools and for them to protect our interests through reviewing all our documents and providing error and omission insurance. So they keep us legal. Well, they do their best to do that. Some people still do illegal things and can't control everything. They just are turned in, complain to the real estate board, or they're let go from their brokerage. Number 24, right? Yes. A broker stops using a registered assumed name. What is a registered assumed name? What must the broker do to comply with law? A, notify the commission within 50 days. Notify the commission within 30 days. That's B. C, register a new assumed name within 30 days. Or D, run a public notice for 7 days at the broker's expense. So a broker stops using a registered assumed name. So who must the broker notify and when? What must the broker do to comply with law? Oops, sorry. The answer here is B. Notify the commission within 30 days. Let's see what else it says here. So the broker must give the 30-day notice per regulation. The broker need not take on another assumed name, nor is public notice required. So nobody wants to participate today, huh? I think I did have some individuals participating last week. And that's okay if you don't. However, it's for your benefit to participate because I can help you out if for some reason, you get it wrong, or if you get it right, I'll salute you. Kudos to you. So number 25, internet advertising requires disclosure of the advertiser. A, unless the user is employing the medium of social networking. B, on the homepage of the site, on each page of the HTML document, or D, in the URL of the ad. So internet advertising requires disclosure of the advertiser where? It's really important nowadays because we have to disclose, right? Who we are. Excuse me. The answer here is C. We have to disclose on each page of the HTML document. Oh, darn it. I typed 1225.3. Let me redo that. So it's 1325C. Okay. Number 26. Dang it. Advertising, including internet advertising, may not mislead the public. We should never mislead. Be transparent, direct, truthful, honest. In that regard, which of the following would be considered deceptive? A website with an excessive number of listings on it. B, An ad stating that the sales agent ran the business like real estate professionals are supposed to. C, a directional sign to an open house that was pointed in the wrong direction. That does happen by accident. Or D, an ad directed at buyers for exclusive representation that stated the buyer may not have to pay the commission. So what's the answer for B? Remember, some of these can be very evasive questions, not very clear. So pay attention to that. And also words like must, always, only. Those are trigger words that should let you know that it will not be the correct answer when there are other better options. So the answer here is B. An ad stating that the sales agent ran the business like real estate professionals are supposed to. Well, how are they supposed to? The public doesn't know, right? We're the knowledgeable ones that have gone through education and courses and training to know that. So that is misleading because the public doesn't know. So including advertising, including internet advertising, may not mislead the public. And it could be considered deceptive. An ad stating that the sales agent ran the business like real professionals, real estate professionals are supposed to. Well, sometimes even real estate agents or realtors don't know what they're supposed to do. So 27, a residential market has fallen on hard times. To make more deals with buyers, a licensee advertises an offer to rebate portions of their commission to any buyer in order to make prospective purchases more attractive. Given this scenario, which of the following applies? A, the ad must disclose that the rebate is subject to the seller's approval. B, the rebate must be made in cash before closing. C, the ad must identify a dollar limit of the rebate. Or D, the licensee may not make this offer as rebates are not legal. The answer here is A. The ad must disclose that the rebate is subject to the seller's approval. So residential market has fallen on hard times and they're wanting to attract buyers. So who owns the property that they're trying to attract buyers to is the owner, the seller, the grantor. So a licensee advertises an offer to rebate portions of their commission to any buyer in order to make prospective purchases more attractive. The seller, the owner, the grantor must approve this. So the answer here is 1327 A. Whenever we're representing an owner or a buyer, we only make decisions based on their decisions. We inform them, we give them resourceful information based on our research and our knowledge and what is public and on statistics, data, and they make the decision. We never make a decision for our clients. Number 28, a sales agent advertises that he consummates more closings in less time than any other volume agent in the market. Pretty good agent, right? The ad lists 4 such competitors listed in rank order of their prior year sales volume. Which of the following applies to this advertisement? A, the ad is illegal since it ranks orders direct competitors. B, the ad is illegal unless it discloses what the ranking is based on and the source of the data. C, the ad is acceptable provided the parties on the list approve of the ad. Or D, it is deceptive since sales volume is not relevant to an agent's proficiency. So what do you think can be disclosed like this and what is needed? So is this a legal ad or is it illegal? Because the ad lists 4 such competitors, okay? So, there's lots and lots and lots of competitors out there listed in rank order of their prior year sales volume. Okay, so they have some data, but it's only on 4. So which of the following applies to this advertisement? The answer here is B. The ad is illegal unless it discloses what the ranking is based on and the source of the data. So it could be from National Association of Realtors or our San Antonio Board of Realtors or whatever Board of Realtors you're located at, or other public knowledge system that has done a lot of resource and compared all agents. So it is illegal to just use the ad that lists only 4 competitors. Because they could be puffing themselves up if only comparing with 4. So it has to come, the data has to come from a third party that is recognized and trusted. Number 29. Which of the following is true regarding office regulations for brokers? Office regulations for brokers. Which one is true? A, in-state resident brokers must maintain a fixed office location. B, additional branches need not have an office license provided it is within the same market area. C, non-resident brokers must maintain an in-state office. Or D, if a broker changes locations, the broker's license transfers to the new office as is. The answer to number 29, which of the following is true regarding office regulations for brokers? A, in-state resident brokers must maintain a fixed office location. So even if we're a cloud-based business, we have a physical address. So there has to be an address related to that brokerage. Let's see what else. So all in-state brokers must maintain a fixed office location, but out-of-state non-resident brokers need not. Any change of the office address requires the broker to get a new license bearing the new address within 10 days. Okay, keep that in mind, within 10 days if they change an office location. Also, all branches must have a branch office license, and it's usually posted in the general area or community area or kitchen area, wherever all agents can have access to it and view it. Sometimes out where the public can view it if there is an office that people walk into. Which nowadays, with so many cloud-based business, we don't have individuals coming to our office, right? Because our office for many of us is now at home. COVID and before COVID, there were already cloud-based businesses. Number 30. A buyer signs an offer to purchase a property. At this juncture, the licensee is required to disclose which of the following? A, that the price agreed to was developed without coercion or market collusion. B, that the buyer should get title insurance or a title abstract examination by an attorney. So what is title insurance? What is title abstract examination? What is collusion, coercion? C, that TREC, Texas Real Estate Commission, requires the buyer to obtain a property inspection. Word to keep attention at, require. D, that the buyer must, those little words, must, also, always, must be pre-approved to satisfy the contract's financing contingency. So a buyer signs an offer to purchase a property. At this juncture, the licensee is required to disclose which of the following? Oops, I didn't enter 29. So what is the answer to 30? Letter B. that the buyer should get title insurance or a title abstract examination by an attorney. If the buyer and the seller are going to do their closing process at a title company, then there is a title insurance that is provided, that is paid either by the seller, by the buyer, split by the two. It's negotiable. So there is title insurance or a title abstract, which examines the history of the title of ownership to see if the person that is selling it is the true owner of that property, and some history on it, and show if there's any liens, any judgments, or such. If it's not a must, if the buyer does not want a title insurance policy, then it has to go through an attorney. Attorneys can do closings, real estate attorneys. However, if there's going to be a title insurance policy, that is done by a title company. That's why it's named a title company. They do the research on the property, the recent history or a more extended history. And they find out about, divorces, liens, deaths, a lot of information and all that. If something is incorrect, it then has to be corrected prior to close. And that title commitment, it's called, is delivered to all parties for their review, and make sure that if the seller has something on there that needs to be corrected, it will be done prior to closing. And if it can't be done, then the property will not close. Sometimes there are missing documents and that's an encumbrance. That is something that's attached to a title. And in order to be able to sell it, they have to quiet the title, right? Because currently it's noisy. It has lots of things, encumbrances. So we must quiet the title. And then we proceed to close. All right, number 31. I believe this is maybe coming to the end. A licensee shows a property to an interested buyer, which the buyer likes very much. During the second showing, the buyer reveals that the house was previously occupied by a person who died of AIDS. The buyer blames the agent for not disclosing this fact and threatens to file a complaint with Texas Real Estate Commission. Which of the following is true? So remember, what things get disclosed and what do not. You should be asking yourself, because there are certain things that we can disclose about an owner and those that we cannot. A, the broker has failed to deal honestly and competently with the buyer prospect. B, the broker has violated a duty to disclose unnatural deaths which have occurred in illicit property. C, the broker has jeopardized the client's interest and could face disciplinary action. Or D, the licensee is not required to make any disclosures or inquiries regarding AIDS. So what is the answer here? What can a realtor disclose? And of course, we can only disclose what is allowed. And if there is something else that could be disclosed, then the owner has to disclose it to the realtor. If the realtor doesn't know, the broker doesn't know, we can't disclose something that should be disclosed because the owner hasn't disclosed it on the seller's disclosure notice or hasn't told us formally. So what is the answer here? The answer is D. The licensee is not liable here. The licensee is not required to make any disclosures or inquiries regarding AIDS or the fact that someone passed away at that property. If it was murder, if it was a death because a repairs that needed to be done on the property or a property that can't be lived in, then that gets disclosed, right? When we know of that. Okay, so that was 1331D. Okay, so we'll finish there and start next session on number 14. But as I mentioned, or I should say, as I mentioned, we may start with some vocabulary next week. Okay. And these sessions that I do are Wednesday at 5 o'clock. If we're having internet issues, I could potentially move it to 6 o'clock. However, 5 o'clock is what I have scheduled, and I used to do in the past for years, and that was Wednesday at 5 o'clock. And sometimes I may do one on Saturday in the morning. For right now, it's Wednesdays at 5 o'clock, and continuing with this book. Vocabulary, this particular book does not have vocabulary. So I'll show the book. Okay, this particular book does not have vocabulary in it. However, there is a lot of vocabulary sources, okay, online. And you can also go to Prep Agent with Joe Juder. He has a lot of excellent vocabulary videos that he uses. However, I use some vocabulary booklets that I have found online and that are really good and have a lot of vocabulary, so that I'll review only a certain amount of vocabulary and go into detail, and sometimes give you life experience to help you understand that vocabulary. And if you would like to purchase this book, in order to follow along, the link to purchase this on Amazon is in the description. So I would greatly appreciate it if you buy it through my link, and then I will get a small stipend or a financial award from Amazon, since I am recommending it to you and because of the author that I'm using, okay, that I have their permission to use it. So it's also my responsibility to recommend it. And I don't do it just because of that. I look through a lot of different books, and I really like this book from this author. There are other books that I like. However, I don't have their permission in order to use it on here. And just for your information, I've been a realtor in 3 different markets: in Southern Oregon, in South Texas, and also here in San Antonio. So I moved to San Antonio permanently January of 2019. So then COVID hit. So I came here to do recruiting with Keller Williams Realty. I was with Keller Williams in South Texas. However, that fell apart. COVID happened, and I ended up going back into sales. So right now I do represent sellers and buyers. I prefer to work with sellers because we can help more sellers, and other realtors can help sell the properties, and both sides get commission. With buyers, that's the way realtors become huge realtors, famous realtors, very financially great realtors, okay, very experienced. It's when representing a lot of sellers, but we need to know our stuff, because our job is to represent our clients with the best knowledge that we can have. So we must continue always studying, preparing, learning, build ourselves, okay, learn ourselves. So we improve ourselves so that we can do the best that we can in representing our clients. Some realtors never work with buyers. They refer them out and they get a percentage, a referral percentage, what we call. I do both. However, predominantly, I work with sellers. And so I have a video that I published last Saturday. It's called Expired Listings, how to get listings with expired scripts. And I'm like, I hate expired scripts. Nobody really likes cold calling or prospecting over the phone. Some individuals do. And however, I really don't, but I do it, and I am able to get some listings from sellers. I also create videos on living in San Antonio, Texas. And I used to door knock and send out letters. So there are many, many ways that you're going to learn in how to generate clients, either sellers or buyers. All right. So I do have different playlists that cover national material only, others that cover Texas only, playlists that cover vocabulary. I've been doing this on YouTube since October of 2020. I did take about a year and a half off to focus 100% on real estate and increase my production, which I did. And now I'm back to doing this and also helping clients, representing clients, and also creating videos for my living in San Antonio, Texas, to attract buyers and sellers on that channel. So there's so many different ways to attract clients, lead generation. So keep that in mind when you end up practicing real estate and when you become a realtor. Okay. Also know that real estate can be easy, but it's not. It's a lot of work. We continue to educate ourselves and we want to stay legal. We want to be transparent, honest, truthful, because our job is dealing with people's lives, one of their biggest, most expensive ownership or asset. We, as an investor, we say our personal home is not an asset, right? Because we can't use the money. Asset is money we invest and gain on it. And if we buy and sell a property every couple of years, then that's an investment. It's an asset. So anyway, I'm rattling on here. So whenever you have any questions, put them in the comments. I do reply to all of my comments. And as I mentioned, I was a retired engineer, so I'm a detailed individual and like numbers. However, real estate, I did real estate investing in Oregon and South Texas and real estate in 3 different markets. So I love what I do, and I hope that this is helping you prepare for your real estate exam. But I'm not doing it for you. Nobody else is going to do it for you. You have to do it for yourself. You have to set a schedule that is you are consistent with. Study every day, even if it's for 20 minutes, 30 minutes. Study vocabulary, study question. Repeat the questions over and over and over until you get 100% score. Don't just stop when you get a 70 score in the practice exam, because the real exams are typically tougher. Every now and then there's an easy exam. You're also going to get questions that you might not, hey, I didn't study that. Well, they're testing our knowledge, our common sense to think. So you're going to make choices, in the multiple choice. You're going to select an answer that you don't know, but it's important that you do select an answer. So again, lots of videos on my channel, and the link on this book is in the description, and also other books. And with that said, I look forward to seeing you next week, and look out for additional videos, which is to educate current realtors that are building their business and learning that there's so many different ways to make business. You can do it part-time, full-time. If you really want to make a lot of money, you want to do this full-time. Excuse me. And I'll create another video on that. But the expired script video, I did that. And you could just take a look at it just to see, what you might end up doing. If you join a team, they're going to ask you to practice those scripts, because they're going to have you either calling sellers. Predominantly, when you're in a team, you're going to be working with buyers. They give you the leads, but you have to work them. Nobody gives you free leads. When you work in a team, yeah, they're going to give you leads, but they're also getting 50% or 40% of your commission in addition to the portion that goes to the broker. However, sometimes that's the way you get started. And don't think about just the commission. Think about what you're learning and what you're doing, and that you're helping people buy homes and sell homes, just like you may be wanting to buy a home or sell a home and help family. Usually I don't deal much with family or friends. It's tougher to tell them the truth sometimes, and we have to be direct and ask a lot of questions. So in this business, ask a lot of questions in order to find out the motivation. Do they really want to buy? Do they really want to sell? That's how we get to know a lot about our client. And that's why here in real estate, you got to study a lot of questions and vocabulary, and more vocabulary. So I appreciate it. Watch my other videos, okay, to prepare for the exam. I have really old ones from 2020. I've been doing this since 2014, first in person at an office at Keller Williams, then on Facebook, and then I grew into YouTube. All right, you all. I love you. I wish you the best. Study, prepare a schedule, take care of your health so that your mind is alert and active. Until next time, catch you later.